So what possible other reforms might we think about? Well, the first, maybe, in order to stop some of the chilling, is to go a little further than we have in the Criminal Procedure Act and have a statutory prohibition on pre-trial court appearances other than for specific defined purposes. Now that proposal, that suggestion, comes from the knowledge that in European jurisdictions, pre-trial court appearances are actually unknown. Before I went to Germany, there's a very good translation actually of the German Criminal Code into English, which is very clear, and you can follow through the whole thing. So I religiously sat down and I read the whole German Criminal Code on procedure, not the substantive criminal law. And I could not work out from the code, because they have it all elaborately set out in the code, I could not work out how the system actually operated in practice. There was just something missing in it that I couldn't grasp, and it wasn't until I got there that I realised that what I was missing was the fact that defendants in Germany and Austria and so on never appear in court until the actual trial. And indeed, the only time they appear before a judge pre-trial is if custodial remand is an issue. Otherwise, everything is simply dealt with on the papers and in the office and by email and by telephone, like everyone else in life does. We don't have people, with 10 or 20 other counsel all sitting around at enormous cost, appearing in court week after week in those jurisdictions. And if you say to them, what about open justice? They look at you in a rather puzzled way and say, what about open justice? People go to the media if they want to. Defence counsel and prosecutors can talk to the media, There's nothing secret about it. What are you talking about? So that may be going too far, and indeed I would suggest it is, but there is a happy medium. What we did in our discussion paper is say, well, actually, if you think about it, there are the following, I think we said, potentially including sentence, 7 events where you would need something to come before a judge. And in statute, you could define that the only time you ever have a hearing in open court before a judge is in these 7 instances, unless you might have an exception, unless it is clearly required in the interest of justice. That would actually stop the churn that we currently have. Secondly, you might have, this was again something that was originally in the Criminal Procedure Bill, but was lost, mandatory identification by the defence of the issues in dispute. That is not contrary to the right to silence, doesn't affect the privilege against self-incrimination. It is simply requiring the defendant to say what it is they're denying, so that the fact finder knows what the case is about. And in particular, if you have a jury system, that the jury knows what the facts are about when they're listening to the evidence. Because actually there's quite a lot of evidence that juries often otherwise listen to the evidence with the long factual frame in mind. So, mandatory identification of issues. Open to the defendant to say everything is an issue, I deny everything, provided that the propositions are not mutually exclusive. So you can say, it was nothing to do with me, I wasn't there, and besides, I don't believe it occurred, because that's not mutually exclusive. But you can't say, I wasn't there and it was nothing to do with me, but if it was an accident and I didn't intend it, and if I did intend it, then I was acting in self-defence. Which often actually is not often, but sometimes is the way in which criminal trials actually operate. Thirdly, maybe a greater role for the judge in the case, pre-trial and trial. Now, of course, in inquisitorial models, judges actually run the whole thing. And indeed, in the trials themselves, the judges do the bulk of the questioning. In the first trial I saw in Germany, the prosecutor and the defence counsel ask questions for maybe a total of 10 minutes each. The judge at the beginning of the trial actually talked for 1 3/4 hours with the defendant as a dialogue. And whatever else you thought about that, it was a case where nobody, including the defendant, would have come out of court and said the defence didn't have their day in court. So, you know, maybe there is a role for saying, actually, the fact finder should have a much more active role in the way in which evidence is elicited. And therefore, obviously, a more limited role for lawyers in court. Maybe a case for some sorts of offences, sex offence cases, considering replacing jury trials with an alternative system of lay participation, like exists in all European jurisdictions. And incidentally, Denmark had a jury system just like ours till 2007. They completely replaced it in 2007 with a system that is more akin to Germany and Austria, and actually, as far as we could tell, universally regarded it as working much better. And if you did that, possibly abolishing a lot of the rules of evidence that restrict what the court can hear. Why? Because the reason why we have enormously elaborate rules of evidence is because even although we think juries are the best things to slice bread, we actually don't trust them. That is, we don't think that they're capable of putting prejudice aside. So an awful lot of the rules that exist are there to eliminate evidence where the prejudicial effect might outweigh the probative value. All of those rules of evidence are simply unknown in European jurisdictions. And they're unknown because they simply take the view you can trust judges to decide what weight to put on things. Which is why, actually, in every European jurisdiction, again, rightly or wrongly, the court will have right at the beginning the whole of the defendant's background, including previous convictions and their drug use and everything else. Because, you know, they don't think that judges are going to be prejudiced by those things. They're capable of weighing up their relevance. And maybe you could think about some alternative models for dealing with some cases outside the formal court system, where the formal court system doesn't really lend itself to good resolution. And we would put maybe some sex offence cases into that category. So that's a very brief thumbnail sketch of a few other ideas we've put forward. As I said right at the beginning, quite a lot of that is sort of lateral thinking. Don't necessarily subscribe to it all and don't necessarily think that I would end up proposing it if it were up to me to propose it. But I think all of those ideas are things worth thinking about. And certainly in my observation of European jurisdictions, with the exception of the Netherlands, which for reasons I won't go into is absolutely horrendous, we actually thought that European jurisdictions in lots of respects worked much, much better than ours. They were more informal, they were more inclusive, they gave parties more of an opportunity to participate, they were not the same alien, formal and disempowering environments that most people walking into criminal courts in New Zealand or England or Australia would experience. Stop there.
Okay.